Hi, everybody, and welcome to NFTs, a global perspective brought to you by the International Advertising Association. My name is Hannah Taylor, and I'm so excited to be joined by all these amazing panelists. This webinar is part of a series of webinars developed by the IAA's Public Policy Council. It took emerging advertising law developments around the world and is bringing relevant content for you today. The IAA believes in smart regulation, which is often the result of close collaboration between government, industry, and other stakeholders, and can both protect consumers and create an environment where businesses can thrive. We're so excited today to be talking to you about NFTs. Next slide, please. So today I'm joined by Kelly Harris from Canada, Justina Zhang from China, Juan Carlos from Colombia, Lydia from Italy, Dina from Russia, and Omri from the United Kingdom. And we are so excited to have all of these amazing panelists here to talk about the various NFT issues that arise from their own jurisdiction. So one of the things that we thought would be important would be to give you a primer on the applicable tech and terminology, because so much of what's confusing about NFTs in this space is that people don't understand many of the different terms that come up, and it makes it difficult to counsel in the space. So we're going to talk a bit about sort of level setting on what it all means, and then we'll talk about each relevant jurisdiction and some of the key considerations from a legal perspective to keep in mind for advertisers when they're trying to either drop NFTs or have NFTs be part of their client's next project. So one of the first things that we often talk about when we talk about NFTs is something called Web3. And to be honest, there's no sort of consistent definition about what Web3 means, which makes it difficult to sort of come to a consensus and give a final definition. But the way that we like to think about it is that a sort of current iteration of the internet or a previous iteration of the internet was really the way Facebook and Twitter and Snap and the rest of the big internet companies thrived. They had a front end that consumers could interact with, and then they had a back end that basically was controlled by them using common web development tools like Java, and then they had a database where all of that information was stored centrally by them. When people talk about Web3, what they usually mean is a sort of similar front end, right? Still an app, still HTML front end that consumers can actually interact with. But what's different is that the back end, instead of sort of being a centralized database, uses blockchain technology. And if it's on the Ethereum blockchain, uses smart contracts that are usable and available to everybody and not necessarily owned by anyone, to make a decentralized application work. And so what that means is the data that's in the back end of a Web3 app or a Web3 company is usually not necessarily controlled centrally, but decentralized, which is part of the reason why we hear the word decentralized so much in the Web3 space. That can really matter for counseling clients in NFT projects, because if the NFT project or the Web3 project is going to use the decentralized backend, there's a lot less control over things like data or the ability to necessarily own what's happening on the backend, and we'll talk about that in a bit. So, okay, I mentioned that with a Web3 company, things are stored on a blockchain. So what's a blockchain? It's important to understand that there's no such thing as the blockchain. There are many blockchains, and each of them work differently based on their unique protocol, which is basically just the underlying software that enables the blockchain to operate and creates the blockchain's own rules. Now, the reason a blockchain is called a blockchain is because it's essentially just a database of transactions that's grouped together in separate blocks. And each block of transactions gets added to that database. So that is sort of the first part of the word. Then we have to worry about, okay, well, why is it a chain? Each block of transactions actually contains a header. Usually, obviously, each blockchain works differently, but the most common ones contain a header. And that header includes a unique fingerprint, or what's called a hash, which is a string of characters and numbers that represent that block's transactions. And all of those transactions are moved into a block. And then those blocks are hashed together, referencing the previous block. So that's very important, because what it does is it creates a chain, right? It actually hashes each block together. And so it's very difficult to mess with any of those with that database, because each block has a header that references the previous one, thus creating a chain. What's exciting about this is all transactions that happen on this blockchain are recorded and publicly available, so you can see everything that's happening on a particular blockchain, and that's publicly auditable, which is exciting. What's challenging from a legal perspective is that each of these transactions is also immutable. Because each block incorporates a hash of the preceding block, anyone trying to modify the content stored in a block will inevitably break the chain. So there's sort of no, we like to say, no backsies in blockchain. What you do or any transaction that you put through is actually impossible to undo. Now, how is a block added to the chain? That's based on the protocol of the particular blockchain, and there's usually two different ways that blocks get added to a chain depending on how the blockchain works. Many blockchains right now are what's called proof of work blockchains, which basically means that a bunch of computers called nodes have to run through repeated calculations to find a solution to a mathematical puzzle that's issued by the blockchain protocol. And each of them is trying to find a valid hash for that block of transactions. Once a computer finds a valid hash, it can broadcast the puzzle solution to the whole network, and then other nodes sort of work really quickly to try to see if that hash is valid. And once all of the computers reach what's called consensus, that a certain transaction should be added to the chain, they all decide, yes, this transaction should be added to the chain. The problem is with proof of work, that can be a lot of computing power and a lot of work by a lot of different computers all over the world who are all racing to try to work together to find a valid hash and add transactions to the blockchain. And given how much work and computing process power this takes, it can create real environmental issues. What's happening now is that many popular blockchains, including the Ethereum network, which is having a big change in the next coming period, they're deciding, this is not really that efficient. It creates environmental problems. It creates, it's hard to scale. Let's move to something called proof of stake. And what proof of stake means is instead of having all of the different computers run through repeated calculations to find a solution to a mathematical puzzle and all reach consensus that a certain block of transactions should be added to the blockchain, instead, validators are used in a blockchain protocol that uses proof of stake. And what that means is that whoever has the most crypto that's native to that particular blockchain staked for the longest amount of time is basically the one that gets to add a block to the blockchain. And other computers on the network called validators, they look and they attest to the fact that the person or the computer who has the most cryptocurrency native to that blockchain staked is actually right in the fact that a certain transaction should be added to the blockchain, and they all reach consensus in that way. Now, what's important about all of this is that nobody does all of this work or maintains this database in a decentralized way with computers all around the world for free. Nobody would do that. That wouldn't make any sense. And that's where cryptocurrency comes in. Cryptocurrency is the output or the digital asset of value that is generated every time a miner generates a valid hash for a new block of transactions. It's basically credit that a computer gets for being able to have done all this work or staked a bunch of currency. It's the value that they get in order for maintaining the blockchain. And what ends up happening is once a certain piece of cryptocurrency is created, it can then live in a marketplace and be traded by other people who are not necessarily miners. But the original creation of it is the economic incentive to validate transactions and maintain and secure a blockchain. Now, examples of common cryptocurrency are things like Bitcoin or ETH. What cryptocurrency normally is what's called fungible. It's basically like one Bitcoin equals one Bitcoin, just like $1 is the same as $1. They're not necessarily unique, but unlike traditional money, no governments and no banks control cryptocurrency. It's decentralized and maintained by the blockchain protocol. Now, you interact with digital assets, including cryptocurrency and NFTs, which we'll talk about in a second, using a digital wallet. Now, digital wallet can be confusing for people given how it's named, because a digital wallet actually does not store cryptocurrency or NFTs or other digital assets. What it really is a type of internet or a type of functionality that allows for what's called a key pair. And what a key pair is what's called a public key and a private key that work together. A public key is a string of a string of digits associated with a particular address on a blockchain. And the private key is also a string of digits, but that one is private. So the public key basically acts like your public address that people can find you, almost like your Twitter handle. It allows people to search for what assets you own. The private key acts more like your password. And these two keys work together in order to be able to view or store or access what assets are stored on the blockchain that are associated with your particular wallet address. Now, most of the sort of danger or hacking in the digital asset space comes from unsecured wallets. So there are a variety of different types of wallets available to allow people to secure things either more or less. We have things like non-custodial wallets, which is just, I want to go on MetaMask. I want to just sign up for a digital wallet like anyone else. I get a browser extension and I'm off to the races. For many clients that we represent, that will not be enough security. So they'll want something like a custodial wallet where a bank or a major crypto custodian can actually custody their digital assets for them or keep their key pair safe. There are things also called cold wallets, where you disconnect your digital wallet from the internet and keep your assets unconnected until you need to move them, and then you connect them to the internet to keep it so that people cannot necessarily hack into it from the internet, which is important. And digital wallets are sort of key to this whole process, because once you own cryptocurrency or you own NFTs or any other type of digital asset, you need a digital wallet in order to be able to send those assets around the blockchain, to send, to be able to mint, and we'll talk about what that means, create different NFTs, and to interact with Web3 virtual worlds like Decentraland or the Sandbox. Now, I mentioned when I talked about what Web3 is that there's something called smart contracts that get deployed. Smart contracts are not a function of every blockchain, but they are a function of the Ethereum network, which is the most popular blockchain for non-fungible token projects. And what smart contracts do, and why the invention of the Ethereum network versus the Bitcoin blockchain was so exciting for people, is the idea that you can actually not only just trade cryptocurrency using a blockchain, but you can add extra functionality called smart contracts that are basically computer programs that are deployed and executed on a blockchain, and they're designed to execute transactions without human intervention. So imagine a situation like, a vending machine where you can go in and you can put $1 into a vending machine and press F1 and out comes a Snickers. No teller needs to be in the back there. That's a self-executing process. Smart contracts are pretty similar. They're just basically computer programs that are designed using code to do certain things by default. The problem is that they're sort of, it's difficult the way that they're named, because a contract in many instances makes it seem like it contains a bunch of prose with legal terms in it that lawyers can negotiate and basically append to a certain digital asset. And that's not what a smart contract is. It's important to remember that it's just as smart or as functional as a computer program could be. So, smart contracts cannot be deleted by default. Interactions with them are irreversible, and they can only really do as much as what a computer program can do. So finally, we're here to understand how NFTs play into all of this. So NFTs, much like cryptocurrency, are digital assets, but unlike cryptocurrency, each individual token is unique, with distinctive ID codes and metadata that distinguish them from one another. And the metadata contains what's called a URI, or a Uniform Resource Identifier. And what that does is it points to an off-chain location where users can see what that token represents. Often when someone uses a URI, they're pointing to a piece of digital art, or they're pointing to some other digital asset that exists elsewhere on the internet. And often an NFT not only points to that other digital asset, but also comes with other rights or benefits that are done in off-chain contracts like license agreements, or other pieces of utility that someone gets, like access to a meet and greet or access to tickets. It's important to remember, though, that when someone creates an NFT or mints one, all they're really doing is executing code that's added to the blockchain where the NFT is being managed. The NFT is not necessarily the same thing as the art to which it points or the asset to which it points, and that becomes important from a legal perspective. Each NFT, it sits in a smart contract and has a unique ID code, and it can show, as you can see in this visual here, which token it is and what owner it is based on their public wallet address. So when you look in the smart contract, you can see what NFTs it holds and who owns them, what wallet address they're associated with. Now, smart contracts manage all of this. They manage the minting of NFTs. They manage the sale of NFTs and the distribution of NFTs, including what wallets get paid what types of money. If you're programmed into that smart contract that once an NFT moves along the blockchain, different public wallet addresses get different amounts of money. And we'll talk about that in a sec. But that is one exciting thing about NFTs, is that you can actually program in the idea that different wallets receive money on a perpetual basis as royalties. Now, it's important to remember that once a smart contract's deployed and executed, it can't be modified. So if there's an error in the logic of the code, or there's a way that someone can hack into it, that can often create real problems. So you want to make sure that whoever is designing your smart contracts and developing them, that they are good actors, that these smart contracts have been audited by other people, so that you're sure that there's not some sort of inherent flaw in there that could end up really either trapping value inside of your project that you can't get out, or otherwise create mischief that will be the downfall of your NFT project. Now, I like this visual as a way to understand how this is all working. I like this because it shows that someone creates some sort of media, maybe a piece of digital art, and that can be created by an artist who's, that artist creates that media. They go to a token generation app like an OpenSea, and they mint, which is that little lightning bolt. And when they're minting, they add in token info, and they also add in not only the metadata, but also the URI. Where should this NFT end up pointing to on the internet to go to the media that's somewhere else? They execute a smart contract. Inside that smart contract sits a token, and the media that's associated with that NFT sits somewhere else. And that's in that little media storage place. So this is a really helpful way of understanding that the token is not necessarily the media, and the media is not necessarily the token. And we have to think of those things differently when we think about them from a legal perspective. Now, okay, we've been in tech world. What does this mean? Why are people using this? The most popular NFT use cases have been for things like art and photography, PFP projects, which you can see like CryptoPunks and the Bored Ape Yacht Club, that allow people to not only own an NFT associated with a particular digital asset, but to also commercialize the art that's associated with their NFT, to do cool things like make movies or develop cartoons based on their character. You see it in music, you see it in ticketing, you see it in gaming and entertainment and fashion, and also in virtual worlds, which we'll talk about. So NFTs, that token that's associated with some other piece of content, have really taken off in terms of a way to give access to people, not only to the content, but to events and other types of utility that are very exciting and a new way to sort of monetize. Many of these NFTs are sold on what's called NFT marketplaces. Not all NFTs are sold through these marketplaces, but these are the most common ones. And really, there are sort of three types. The first is OpenSea, which is essentially like an NFT eBay. It doesn't really conduct any independent verification of whether a party has a right to sell an NFT. It's just a place where you can go and mint your own NFT and sell it to the public and buy other NFTs. That's a little bit different than curated art auction sites like Super Rare or Nifty Gateway, which conduct some verification of creators and their work, and really sort of decide who can actually sell NFTs on their marketplace. And then you have marketplaces that are created and built for a single company in a less decentralized environment, like an NBA Top Shot. Now, we hear the word metaverse in this space a lot as well. And the reason that the metaverse is related to the NFT space is that there are some metaverse worlds like Roblox that still use, they're basically just like a video game or a virtual world in the same way that Web2 gaming companies or virtual world companies always operated. But the sort of invention here, or the iteration of the internet, is companies like Decentraland and the Sandbox, which are built using blockchain technology. And each of these worlds, when they use Web3 or blockchain technology as the back end, provide functionality to mint NFTs. And each asset, whether it's the land, whether it's an avatar, whether it's a piece of digital art that hangs on a wall inside the metaverse, is its own NFT. And the worlds allow you the functionality to mint NFTs that represent each of these individual assets. And then they provide the front end, or the art that sort of connects to that back end NFT. And the idea is that you could take these assets off of these worlds and trade them on OpenSea or move them into interoperable lands. And so the exciting piece is that we're sort of developing this interoperable internet space where you can be a persistent entity using NFTs and travel along the internet as one persistent person instead of being like one person on Twitter, one person on Instagram, etc. Now, we also hear a lot about DAOs, which come into the NFT space quite a bit. DAOs are decentralized autonomous organizations. They're basically a subreddit with a bank account. There are hundreds of DAOs for hundreds of different things. And mostly what they do is use smart contracts to execute protocols, basically like a new type of corporate entity, although not in the US, at least legally recognized in any particular way. And because they take many different forms, ranging from entity lists to LLCs to offshore foundations, it's hard to say exactly what a DAO is. But basically, a DAO is just a decentralized organization that works together using blockchain technology. Now, here's the applicable law and considerations for advertisers that's in the US specifically. Now, one of the things that's difficult is that we don't really have any one specific law that regulates any of this. We have to look at a patchwork of US, state, federal, local laws and regulations to figure out exactly how to navigate this world. We have intellectual property considerations, thinking about what types of rights you have when you want to sell an NFT versus what rights you want to grant to owners who buy NFTs. We have consumer protection issues, thinking about whether or not consumers understand what they're buying. There's been significant securities concerns, thinking about whether or not a particular digital asset or a particular project is deemed to be a security under what's called the Howey test from the Supreme Court of the United States. Essentially, if an NFT is meant to serve as an investment product or service or scheme, it's more likely to be considered a security. And we have some class actions out there right now with NFT projects in particular, trying to figure out exactly how the securities laws apply to the NFT space. So we're watching that closely. There's gambling laws, which worry about whether or not someone's wagering something of value and combining it with consideration and chance and risk. So we really want to make sure that that any given NFT project, whether it's because things change based on their attributes or whether it's because you have to stake something of value and actually wager something in order to get a prize. There's many different ways that NFT projects can subject themselves to gambling laws. So it's something you want to think about. The Office of Foreign Asset Control is a big thing in the NFT space because many people who are our computers who are operating on the blockchain are anonymous. And in the US, it's actually a sanctionable offense to do business with anonymous actors who may be considered sanctioned persons under US law. So a lot of what NFT projects have to contend with is figuring out how to make sure that they're not doing business with bad actors. You have tax considerations. The commodities world has also stepped into the digital asset space in a big way with two major proposed pieces of legislation in the United States looking to make the Commodities Future Trading Commission the main regulator in the US of the digital asset space. So we'll see whether or not that gets any traction. Sometimes there are issues relating to money transmitter laws. So if your NFT project involves buying and selling virtual currency or converting virtual currency from fiat or dollars to digital assets, you can actually end up accidentally triggering the money transmitter laws. So definitely something to think about. And then practical considerations. Do you have the right marketplace involved? Does your NFT have utility? And can you make sure that you can provide that to people? Who's maintaining the digital wallet and opening that and securing it and making sure it's okay? Do you have terms and conditions for consumers that understand what they're getting with their NFT project? Where are you storing the underlying asset? Do you have a charity that's involved and how are you dealing with them? And then, of course, beware of brand safety issues. We've had many hacks in the NFT space. We've had huge issues with stolen NFTs and exploitation. So if you're licensing a particular artwork that's based on an NFT project, or you're deciding to do a huge project based on the fact that you own a particular NFT, be mindful of the fact that NFTs can be stolen and moved around the blockchain, and sort of basing a huge project on an NFT can at this point be a bit risky. So make sure all stakeholders are on board. And with that, I'll turn it over to Omri for the UK.
Hi, Anna. Thank you very much. Thank you for having me here in the presentation. It's great to be here. So I'll talk a bit about the sort of considerations that one would have to take when advertising or dealing with more generally with cryptographic assets, including NFTs in the UK. So as a starting point, as Anna mentioned, actually, the kind of law and regulation that applies to cryptographic assets is not exactly, captured under one act or one particular body of law, but it's rather a patchwork of different, laws and regulations. And that is because, and at least those are my 2 cents, cryptographic assets, including NFTs, are not really products, services, or experiences, but rather infrastructure on which you can build any of those that I've mentioned. So, unhelpfully, and as typically lawyers do, the answer as to what applies or what are NFTs it depends. So as a base layer, let's say NFTs and other cryptocurrencies are cryptographic assets, as Anna explained already. And in the UK, the sort of minimum available regulatory framework that applies to cryptographic assets is captured under anti-money laundering. So as a base layer, service provider that offer exchange services or custody services need to register with the Financial Conduct Authority. That is in connection with providing services, in connection with crypto and NFTs. And whereas the advertising is currently governed under the Advertising Code and supervised by the Advertising Standard Authority. And that requires communication to be clear, transparent, informative, and not misleading. Effectively, all measures that are geared towards protecting the consumer. Now, however, depending on the type of rights that attach to crypto and NFTs, or the way that they're incorporated into other products or services, NFTs and crypto can also fall within financial services regulation and gambling regulation. So in terms of, if we look at financial services regulations, to provide a couple of examples, if your NFT or your crypto provides incentives such as, for example, governance right over a particular company or body corporate, meaning I collect an NFT and then I'm part of a collective together with all of the other holders of that particular collection to determine how the company will behave, how the company will invest funds, and so on and so forth. That starts to resemble a lot, for example, a share in a company as to when it comes to a voting share in a company. Similarly, if your NFT or crypto provides holders, meaning those that have purchased or otherwise collected the relevant NFT or crypto assets, and they receive financial incentives in the form of something that resembles dividends. And if you're not familiar with crypto and NFT, you might ask yourself, why are we talking about this? But when you look at the market, it tends to be those that we are mentioning tend to be very popular incentives. That present a considerable amount of risk, because these type of rights attaching to the NFT increase substantially the risk for the NFT or the crypto to be deemed as a security and to fall under financial services regulation in the UK. Of course, if that's the case, or where that is the case, the type of regulatory framework that applies to all of activities pertaining to the relevant NFTs are considerably different. You become subject to financial promotion, which is subject to very stringent requirements. The offering of these particular instruments requires you to apply potentially for authorization with the financial services regulator in the UK. So effectively, you want to make sure that the product you're offering falls outside of it. If you are a financial technology company, perhaps you can think about, going down the security token road, but it's very, it's very demanding from a regulatory perspective. Similarly, e-money tokens fall within the definition of e-money, which is electronic money and other type of regulated instruments in the UK. And so you always need to make sure that the token or the crypto, the crypto assets or the NFT that you want to release is not such as, it doesn't present characteristics that make it a security or an e-money token. From a gambling regulation perspective, it's also interesting because rather than the inherent characteristic of the NFT, what you would be looking at is more the way it is integrated into different experiences or services. So if you think about a video game, and as a gamer myself, I was very excited at the prospect of owning in-game items finally, because as a gamer, it's not the nicest thing. You spend 10 years playing a video game, and then the day you leave the video game, that's it, you're left with nothing. Players have always craved the ability to own the item, to be able to exchange, to sell them or exchange them. However, the moment you integrate NFT as a reward within video games, then that suddenly starts to look a lot like potentially a gambling activity. And again, the type of regulatory framework that applies to all activities relating to gambling activities, including the advertising of gambling products or services, is subject to stringent and separate rules, in addition to those that would already be captured as related to cryptographic assets. Hannah, if we could, or sorry, if we go to the next slide. So currently, as mentioned, these cryptographic assets are the offering and advertising of cryptographic assets rather is governed under the advertising code. And again, it's all about transparency, making sure that the consumer or whoever is subject to that marketing communication is capable of appreciating whether that product is suitable for their particular circumstances. What's interesting, and I'd say also hopeful for the NFT industry, is that there is a proposed change for the financial promotion regime, which, as mentioned, in the previous slide, relates closely to financial services. What's interesting is that through this new implementation of the financial promotion framework, cryptographic assets are recognized as high-risk assets, meaning they're going to be subject to very stringent requirements when it comes to the promotion of them. But currently, the current draft limits rather the application to fungible cryptographic assets, which is very interesting because it would mean that NFTs, which tend to appeal more to creative and tend to be used, for a variety of reasons other than, as a method of exchange or transferring of value, but rather as a vehicle through which to transfer culture or to implement, particularly interesting, for example, ways of promoting a company, customer engagement, those seems to be carved out. This raises, interesting question because NFTs tend to be developed on top of certain standards. You might have heard of different, how can I say, different tokens, type of tokens, let's say. So you have ERC20, ERC721. So these ERC20 tends to be the token of prime reference on Ethereum, like on which to build, fungible currency. ERC721 is sort of the standard for non-fungible, but there are other standards which combine the two. For example, ERC1155, which tend to be very popular in video games, and being a hybrid, it would be interesting, I think, to see how the regulator enforces financial promotion and whether it will deem, these type of NFTs developed on top of this standard as fungible or non-fungible. My assumption is it's going to be on a case-by-case scenario. They will look at the volume and then they will determine that. But I just think it's interesting because even where regulator try to carve out certain type of products to encourage industry adoption, you can see how it can get very difficult if you start to focus your legislation or regulation around technology rather than activities. So I think it's very, very interesting. I mean, it's a bit of a nerdy argument, but I find it interesting. Other considerations and risks that that you may want to take into account whenever you get close to NFTs or even the promotion, especially if you have, some revenue share on sales of NFTs, for example, you're involved in that, is taxation. Different rules apply. Some are still a bit unclear, particularly around value-added tax, at least in the UK. Others are more defined, but they are unusual. And so it's very important, for advertiser or whoever is get involved with an NFT project and get a profit in the form of cryptocurrencies. So for example, you sell an NFT, you get Ethereum, to understand the stage at which tax liability applies to you and how you calculate that. So I think that's important and interesting. And then other considerations on the next slide revolve around, and again, as Anna mentioned, intellectual property and data protection and privacy. From an intellectual property standpoint, what I find interesting is you need to make sure, of course, that the IP that you use is clear, that you sought the appropriate licenses. If it doesn't belong to you, if it belongs to you, you want to make sure that you understand fully what type of rights you're giving away, and that is in line with the vision for your project. But also, what I find interesting, and that used to happen a bit more, last year rather than now. I think that now the industry is becoming more sophisticated. But what you saw were very large franchises, particularly in sport, providing a license over their brand, for example, for 2 years, to some, let's say, to a blockchain operator or some other provided, services within the blockchain, and over their trademark and over, for example, the other form of intellectual property that they hold. But then the problem is that many times, like when you upload content in association with a crypto asset in order to create an NFT, so you can look at it as 2 different layers, you often use not the blockchain because that would be inefficient at this stage due to data limitation, but you tend to use other type of distributed databases. So all of this to say, the moment you upload content on one of those databases, for example, the interplanetary IPFS, Interplanetary File Storage System, apologies for the lapses there. But the difficulty that you might encounter is that you don't have the freedom to access and take down the content, and you need to rely on that content not being stored on any of the network that supports IPFS. So on the computer where the content is stored. Effectively, you can commit an IP infringement that you cannot then take down, and you can sort of try and reach out to centralized marketplaces like OpenSea, for example, asking them to take down the content. But the point being, the crypto asset is out there, and unless the smart contracts allow you to do that, you cannot just reach out to someone else's wallet and take it away from them. And the content is also relatively out of your control. So it's very important when it comes to IP rights, especially when you partner with large brands, to make sure that the licensing period covers, potentially the life of the right, but that would depend, on the exact structure. And then on data protection and privacy is exactly what Hannah said. The public wallet address, especially from a GDPR perspective, can be deemed as personal information because you can use it in conjunction with other information that is available online to identify a person. And whilst crypto and NFTs, started if you want, historically due to, by cypherpunk movement, so those that wanted to protect anonymity, in reality, once I have your public wallet, I can see all of your activity. I can look, it can be used as it can be a very invasive technology. That's what I'm trying to say. So definitely data protection and privacy are at the core of, should be at the core of your strategy and the considerations you give when you get involved in a project. Then finally, I would say the last slide, I believe, and this is a step-by-step guide, and I've included here as a sort of a map to follow. If you decide to get involved, keep in mind all of what we've discussed today and all of the different areas making up this, patchwork exercise whenever you design it. But the last thing that I wanted to mention, because I'm wary of time and I don't want to overrun and take time from someone else, is MiCA. So it's a regulation which is on the last slide. Thanks, Anna. So it's a regulation on marketing crypto assets. Now, this is an EU regulation, and since Brexit, sadly, the UK is no longer part of the European Union, so it won't directly apply to the United Kingdom. Nevertheless, it's going to be important for the United Kingdom to understand how MiCA will operate. Because I believe that the government will seek some level of equivalence to be able to, access the European market. So I expect UK regulation to develop in a similar fashion, and MiCA introduces a harmonized framework and introduces some important rules. And it will predominantly, again, NFTs, which I think is interesting, are currently not covered under MiCA and under, the obligation to be authorized or register with a competent regulator. But which I find interesting. So NFTs, there seems to be a regulatory push for NFTs right now to fall outside, or at least in the periphery of this regulatory framework. So that gives a bit more of an opportunity to experiment with them until the regulation changes. But so if you issue tokens and if you provide services, particularly exchange services or custody, that tend to be very important for advertising agencies. So please, if a client engages you to, create, for example, an NFT project and to put parties together in order to do that, just make sure that you speak with a lawyer in your own jurisdiction to make sure that that holding, the Ethereum on behalf of your client, for example, to distribute later on, does not result in any sort of regulatory risk. Because in the UK, that would result in a regulatory risk, and you would be infringing. So. I know it was a bit rushed, but I hope that this sort of covered the UK. Thanks again, Anna.
Thank you so much, Omri. And now we're going to hear from Kelly from Canada.
Hi, all. Thanks for joining, and thanks to Hannah and IAA for hosting us today. I'm Kelly Harris. I am an advertising lawyer at Harris & Co. in Toronto, and I'm here to speak about the impact in Canada. So many of the same issues that Hannah and Omri raised are applicable in Canada as well. Like other jurisdictions, security law is a really important consideration in Canada. To the extent that NFT activity is regulated under security laws, there is similarly a very complex regime that could apply, and very powerful and active enforcement agencies. So, for example, similar to other jurisdictions, there are potential registration requirements as, potentially a securities dealer or an advisor or as a marketplace. And this obviously is going to apply to the cryptocurrencies that are associated with the blockchain on which the NFT is minted. But the larger concern is really where it could also apply to the NFTs being issued themselves, because often advertisers don't realize that this could be a regulatory regime that applies to them. So the registration requirement's a big one, but there's also specific provisions in securities legislation where false or misleading representations are prohibited. And the securities regulators also have a really broad power to regulate conduct that they think is contrary to the public interest. So on the false or misleading representation side, things that could be considered specifically false or misleading in the context of securities law are things like, disclosure of information or lack thereof that investors would consider relevant or important in deciding on whether to invest, prohibitions against making an unbalanced or overly promotional statement, or relying on disclaimers or offering documents to clarify those kinds of statements. So this, really raises a regulatory risk for advertisers who, as I said, are otherwise unregistered parties. For example, if an advertiser were to be continually engaging in practices that regulators might find exploitative to investors or potential investors. And it's notable because the highest administrative monetary penalty that a securities commission could order under these public interest powers goes up to $5 million, plus disgorgement of any amounts that were obtained due to non-compliance. So that would be really tough if you sold a bunch of NFTs and then you had to disgorge all those profits plus maybe $5 million. So that, the securities issue is a big one. There's also anti-money laundering laws. So depending on the activity, there's also registration potentially with FinTract as a money service business. So that kind of goes to the first point about registration requirements. Taxes, as Omri mentioned, in Canada, it's likely a taxable transaction. So NFTs need to be aware of the potential tax implications. These purchases are not anonymous. And in fact, the Canada Revenue Agency, which is the federal tax regulator, won a decisive court battle to obtain customer data from some crypto exchanges. And the CRA now coordinates to some degree with other exchanges to help it track the movement of digital assets. And in general, the CRA treats cryptocurrency like a commodity for the purposes of the income tax. And so this means that any income that's from transactions involving cryptocurrency is generally treated as business income or as a capital gain, depending on the circumstances. So when you buy an NFT, it's a cash out of the cryptocurrency, which would have a tax implication from an income tax perspective. And I should say I'm not a tax lawyer, so you should definitely be reaching out to your accountants or your tax lawyers to get a specific understanding of your circumstance. The other tax issue, sorry, Hannah, one more on this point. NFTs might also give rise to GST or HST obligations, which is a value-added tax in Canada. And it's a bit complicated, but fungible cryptocurrency, like the Bitcoins of the world, they arguably meet the definition of money. So a little bit different there, but a non-fungible token doesn't really meet that same definition. So what this means is that, the rule is if you are generating over $30,000 in annual revenue, then you have to start charging value-added tax. So keep that in mind too, that, you may be subject to those registration requirements and collection requirements, and they can come after you for that after the fact. Okay, next slide, please, Hannah. Similar to the other jurisdictions, intellectual property law is a big issue. Is there an actual assignment of the underlying intellectual property? Did you get an assignment? Do you have a license? Is it going to expire? What are you actually selling? And those, you need to sort that out before you start, selling these NFTs. But the larger issue then is how are you representing this to consumers, right? So make sure you know what it is that you have and what you're able to actually sell, and then make sure that what you're representing in advertising it tracks onto that. So similar to the UK and the US, there are misleading advertising laws and self-regulatory codes in Canada. Generally they prohibit making a false or misleading representation. And if you're claiming that, or being unclear about ownership of the underlying intellectual property, you have a risk there too. And really, the standard that we're dealing with in an advertising context is a credulous and inexperienced viewer who only kind of sees the advertising one time. And in new industries and new markets like NFT, you really can't assume that people understand things, right? The industry is full of credulous and inexperienced viewers. So that's something to keep out, to be really clear about what it is that's being sold. And it kind of tracks on to another issue that's a little bit unique in Canada, which is we have consumer protection laws in each province, which give consumers making transactions online and in other sort of specific, door-to-door salesmen and online over the telephone, these more vulnerable transactions. In Canada, consumers have more rights in those kinds of transactions. And some of the obligations on merchants to have a valid enforceable transaction online is to make a bunch of disclosures, like prescribed disclosures to the consumer, very specific things you have to say to them. You have to follow up with a receipt to the consumer within 15 days. If you don't do these things, then consumers have the right to rescind their agreement in addition to damages. So you can imagine how, this tracks on to an NFT transaction. I mean, the first question is whether or not it would even apply, right? Like we typically apply these consumer protection laws to the sale of goods or services. So like other jurisdictions, when you have a virtual item, there's a lot of debate as to, what is it? And we've seen that kind of debate in Canada. Omri mentioned the video games and in-game tokens and that sort of thing. Like the idea of those being a good is also being debated right now as well. So this is something to watch out for. I mean, obviously you get into an issue with disclosing merchant name and contact information, which is a prescribed disclosure under consumer protection law, which can be an issue, right? Given that many sellers might be anonymous in some cases. The risk here though is, having to refund all of the money and return the NFT would be the remedy that these consumers would have if those disclosures are made. Obviously a huge challenge to give refunds in the context of crypto purchases and, there's a transaction costs as well. So it's not just the cost of, or the disgorgement of whatever the purchase price was, you're out that transaction cost, which could be hundreds of dollars. All right, next slide, please, Hannah. Overall in Canada, what advertisers need to know, I mean, it's very similar to other jurisdictions. Avoid the securities pitfalls and engage an expert, really, because these laws are very specific. They're provincial in Canada, so it's a little bit different in each province. A reasonable investor in general should not be drawing an incorrect inference regarding their investment. It's a similar concept to the false or misleading representations and kind of general prohibitions for, against doing that in general advertising. So it's kind of the same thing, but a little bit more specific because it's specifically regulated under securities legislation. But things to avoid are words with special meaning. So preferred, guaranteed, liquid, indemnity, really promotional things. Don't overstate any sort of value or an expected return. Being clear from an intellectual property perspective, but it also goes to, not making a false or misleading representation. Be clear on what's being transferred to purchasers and make sure that that's actually what is, you're able to transfer. And then consider the risk that you have with the consumer protection requirements. If they were to be considered subject to these laws, what is going to be the practical implication if a purchaser were to seek to rescind their purchase after the fact, and where would you be on that front? And then, just a mention on the gambling issues in Canada, we have similar issues. So if you're overlaying, other promotions, you need to make sure that you're considering, could this be governed as, prohibited gaming if you have a purchase and chance, and there isn't a no purchase method of obtaining that. So that's my update from Canada. And with that, I'll pass it along to the next.
Thanks so much, Kelly. And now we have Dina from Russia.
Hello, everybody. Hannah and I thank you for inviting us to this webinar. And I will tell a little bit more about regulation of NFT in Russia. Similarly to the situation with my colleagues and their jurisdictions, there is no clearly established rule for NFTs, and you would need to look at the set of very different laws to see what your specific object should be classified and regulated as. The first of them I'd like to mention is the Civil Code, which introduced the general concept of the digital rights. But the main regulation we should be looking at is the Federal Law on the Digital Financial Assets, which was introduced several years ago as sort of response to a huge volume of different crypto-based assets and projects which were trying to be released locally, but it has entered the force only in 2021. And the Federal Law on the investment platforms, which was initially introduced as a sort of an effort to regulate crowdfunding activities. In addition to these laws, a couple of certain amendments reflecting the current situation with digital assets were introduced in the law of advertising. These regulations has introduced basic concepts for such objects as a digital financial asset, digital currency, and digital utility rights. And to understand what your specific program and object falls under, you would need to understand every one of these concepts. The digital financial assets are defined as digital assets, digital objects of the civil law, four types. It is either monetary claims, the possibility to exercise the right under securities, the right to participate in the capital of non-public company, or the right to demand the transfer of equity securities. The turnover of these assets should be built within the framework of information system, which requires special infrastructure and special authorization from the Russian regulator, the Bank of Russia. All entities such as exchanges would need to have relevant authorization issued by the local regulator. In comparison, the key features of cryptocurrency under the Russian law is that it is defined as a digital code. It can be used potentially as a means of payment or investment, and there is no single obligated person behind this digital code. If we are going to the utilitarian digital rights, they can be issued only by a specific investment platform, which is a special subject introduced by the law on the investment platform, which also has relevant permission issued by the local regulator. And I would say that the utilitarian digital rights are the ones that are closest to the subject of our discussions, because under these rights, you can acquire or sell the right to demand the transfer of a thing, the right to demand the transfer of exclusive right to the results of intellectual property, or the right to use the results of intellectual property. It is also possible to demand the performance of work or the provision of services. So your first step would be to understand whether your NFT can fall under any of these regulations. Hannah, can you please pitch in the next slide? So, however, if we are looking at the current projects being released in the last couple of years, we see that the CBR, at least at the current point, does not pay a lot of attention to this sphere. And we see that while a lot of projects are being released, most of them in some way are related to art. The NFT were released by Hermitage, Art Place Center, Zaryadye, Kulturny Center. Only recently, the Republic of Yakutia has released their own NFT project related to the deers, when you can buy an NFT and you have a GPS of deer and certain contract to purchase the certain amount of reindeer and horns. All of these projects are somehow released either under the different jurisdiction, or they in some way contain disclaimers that these rules does not apply to them, and they are subject to a different set of regulations. However, we see that the CBR is paying more focus to this sphere, and in order to be compliant in any future endeavors, you would need to understand the potential regulation of your particular project. In particular, a lot of attention is paid to the issue of cryptocurrency and payment in cryptocurrencies. And you need, given the specifics of usual structure of NFT project, you need to take into account that there is a strict and explicit ban on accepting cryptocurrency as a payment for any types of good or products being sold locally in Russia. In addition, there is a ban on the publications of information about the possibility of accepting cryptocurrency as a payment. So these restrictions are being very closely monitored by the CBR and should be taken into account in any case. Next slide, please. In general, it should be said that there are several key issues to keep in mind while releasing your project locally in Russia. First of them is to consider whether your NFT will be considered as any part of specifically regulated objects under the Russian law, and the associated regulation and restrictions may vary differently based on no restriction at all to complete ban or to the obligation to issue it through the special type of subject with relevant local license and local office. Similarly to other jurisdictions, you would need to observe general provisions of IP laws and to general and special provisions of the law on advertising. And with respect to the digital assets, the law on advertising requires to name the issuer, to disclose information about the terms of the issuance of such digital assets. It also, similar to other jurisdictions, prohibits you from guaranteeing any kind of income of these assets, and should include a general warning against the high level of risks associated with such assets. Similarly, given the turnover of NFTs and relevant digital assets, you will have to consider tax issues and potential regulations which may be introduced by the CBR, given that we see that relatively more attention is being paid to this sphere, especially considering the current situation. In particular, with respect to the NFT, we see that there was a bill being introduced in May, which suggested defining NFT token as a non-fungible token for unique digital rights in the form of interchangeable data stored in DLS system. And the NFT was proposed to be included in the list of intellectual property and means of individualization. However, I wouldn't say that this bill has a lot of prospects of being adopted in any near future, since it was negatively assessed by the government, and the government told that basically the current concept cannot survive within the Russian legislation system, and it creates additional legal gaps, and in general cannot be adopted in the way it currently exists. So we are keeping a lookout for the things and how the regulation would go, both with respect to the different types of digital assets and NFT in particular, and I hope to see that NFT will have a bright future in Russia. That is all for me. Thank you for the time.
Thank you so much, Dina. And now we have Lydia from Italy.
Thanks. Hi, everyone. Thanks, Hannah and IAA for having me. I'm Lydia Mendola. I'm partner in Portland Cavallo, and I am an IP and advertising law lawyer. So as far as Italy is concerned, blockchain, NFTs, digital assets, and digital wallets are not legal in Italy, but a comprehensive legal framework has still to be set out, like in other jurisdictions, as we heard. Most recently, Italy enacted legislation legislations that deal with the blockchain environment and some of its players, cryptocurrency has been partially regulated, apparently considered more sensitive argument when compared to other kinds of crypto assets or crypto activities like NFTs. Specifically, Italian law provides for a legal definition of blockchain and smart contract. In particular, the smart contract, according to Italian law, is equivalent to a written contract as long as parties are identifiable. This is an important point since, as we know, transactions on blockchain can be anonymous. And if this is the case, the smart contract does not meet, according to Italian law, the formal requirement of written form, which is required in some cases, for example, for the licensing, for proving the licensing contract. Furthermore, providers of virtual cryptocurrency mediation, conversion and settlement and e-wallet services are subject to anti-money laundering, know your customers and suspicion transactions reporting rules. This piece of Italian legislation are focused on fungible tokens, which basically means cryptocurrency. As far as non-fungible tokens are concerned, it has been pointed out that in certain cases where the speculative purpose is predominant, the application of securities regulations might be triggered by NFTs. This is true when the NFT falls within the definition of financial products under Council of Regulation. An NFT can become classified as a financial product when it is offered and presented as an investment product and when the final goal is mainly speculative. Whenever an NFT can be classified or falls within the definition of a financial product is something that can be verified on a case-by-case basis. Next slide, please. Since NFTs can be considered financial product under Council of Regulations, this might trigger the application of disclosure and other information duties on advertising messages relating to the offer of a security. In the light of the above, it is advisable to proceed with caution when there is a potential security risk due to the nature of NFTs. Disclosure and information duties might also be triggered by the sale of NFTs that cannot be classified as securities. Indeed, an NFT might fall within the definition of digital content or digital service, both recently added to the Italian Consumer Code. There are no precedents or statements so far from the competent authorities that can help us to understand without any doubt whether an NFT is a digital content or a digital service, but it's reasonable to say that an NFT falls within the very broad definition of digital content since it is made by data that are produced and supplied in digital form. This is the definition given by Consumer Code. Example of digital content are applications, video files, audio, video, digital games, ebooks, etc. Assuming that an NFT falls within the definition of digital content, Article 59 of Consumer Code would apply, and pursuant to this article of the Italian Consumer Code, the right of withdrawal would be excluded from contracts that regulates the sale of digital content, as long as the supply of a digital content through a non-tangible medium starts with the consumer's prior express consent and acknowledgement that they thereby forfeit the right of withdrawal. Therefore, exhaustive information to the consumer might exclude the enforceability of the right of withdrawal. This is a sensitive point since the exercise of the right of withdrawal when it refers to the NFT presents more than one technical issues. For example, the return of the NFT presents some technical issues. This sensitive point, the one of return of the NFT and the other one of the enforcement of the right of withdrawal, has been addressed from a technical perspective that has led very recently to the publication of a new standard protocol called ERC 2721R. that apparently gives the NFT's purchaser a right of second thought with respect to his or her purchase, and therefore allows for the refund of the price paid for the minted NFT. Based on this protocol, those who mint the NFT will not be able to collect the price until the cooling off period expires. This way, by the time of the cooling off period expires, the purchaser can make a return to the the return of the purchased NFT by automatically obtaining the refund of what was previously paid. We are going to see if this protocol will become mainstream. The right of withdrawal is not the only one important. The only one, of course, the only one regulated by Consumer Code, which is applicable, as we said, to the NFTs. The Italian Consumer Code provides a number of disclosure and information obligations for the purpose of protecting the final consumer. Such provisions are mandatory and enforceable regardless of the law applicable to the terms and conditions that regulate a specific transactions, and any different agreement could be considered invalid. Moreover, as already happened actually in the past, if the contractual clauses do not recognize the right of consumers, the competent authority could consider the conduct as an unfair commercial practice with penalties up to 5 million euros per violation. Again, it is advisable to proceed with caution when NFT's international campaign is launched, and we recommend a check of the terms and conditions in the light of the mandatory provision provided by the Consumer Code. As in other countries mentioned by my colleagues, NFTs are subject to current provisions related to fair and disclosed advertising. And NFTs campaigns must not be false or misleading, no misleading representation must cover ownership of the underlying artwork or must convey the message of easy money gaining. In addition, the promotional purpose of the message must always be properly disclosed. Next slide, please. Italy is still an early stage in this market. Cryptocurrency and NFTs are known on the market, but the phenomenon is not mainstream yet. Nevertheless, Italian luxury and fashion brands are leading this new market. For example, Dolce & Gabbana and Gucci projects, among others. In the case of brands, they usually do not directly mine the NFTs, but rely on the external services provider that cooperates with the brand for the minting and sale of NFTs on the selected platform. The main concerns they have are therefore related to the regulation of IP rights through license agreements that must protect the IP asset to the maximum extent possible. A proper commercial rights and licensing strategy is key in order to meet IP owners' needs. Some brands and tech influencers are opting for the so-called utility NFTs. This kind of NFTs has leverage on the community that brands and influencers already have or want to increase. Utility tokens serve a specific use, such a use on a platform to redeem a special service or to receive preferential treatment to service in any ecosystem. This is the case again of Dolce & Gabbana project and Gucci project, amongst others. In the same way, tech influencers use utility token to allow followers to attend events, obtain special prices for merchandising, spend some time with them, and etc. Other activities. The regulation of utility token is complex and to some extent still unclear, depending on the kind of service attached to the NFT that might have a different treatment also from a tax perspective. In the light of the above, we suggest our client an in-depth legal analysis of the utilities attached to the NFTs. That's it as far as Italy is concerned. Thank you.
Thank you so much, Lydia. And now we have Juan from Colombia.
Hello, everyone. I'm happy to see that you've been standing for this so long, and hopefully my presentation will be a little bit brief, because certainly, as my colleagues have mentioned, in the Colombia, the matter that is being regulated is still very much on the diapers, I will put it. Actually, I would say even more, it's kind of schizophrenic, because if you look at this description that we're putting here, just recently, the Central Bank of Colombia and all the financial authorities decided to get together to figure out exactly what was a cryptocurrency and what was a digital asset and how they were going to deal about it, and they were clueless. And in the sense and the approach that they took to this matter was not to say what is an NFT, we don't have a definition, not to say what is exactly a cryptocurrency, we don't have a definition, but instead they decided to go to what they are not. So basically, they went towards the harsh definition that they are not money, they don't technically have a value, they cannot demand to be an equivalent with the Colombian peso or with any other fiat money. So they said, well, for us, we don't know what they are, but we know what they're not. And certainly, basically, what they wanted to exclude any possibility to make it a liquid asset. Nevertheless, please, next slide. Nevertheless, they went to as far as create a registry in which Colombians have to state if they own any crypto assets or any digital assets, whatever they might be. And that certainly the NFTs fall into this category. And the NFTs that we care about are basically for advertising purposes. Hannah, if you can move towards the next slide, please. And so they created this as recently as December last year, a database, basically, so that everybody will be able to register the kind of assets that they had and state their value, not knowing exactly if they were going to be properly assessed or properly valued or in any sort of, let's say, coherent manner. Just, I will say, to make a presentation, to make a show of that they were somehow trying to provide a background of legal support towards these activities, or whoever was involved in this activity, to avoid claiming that they were entering into money laundering. But again, as you see, the concept or the length that they can go towards regulation is still very, I would say, naive. I would say somehow unknown. I would say undefined. So if we go for the next slide. So basically, it leaves us advertisers on what we care about in the topic, because as my colleagues, I'm not into financial regulation or tax regulations. Is mostly what advertisers need to do. It's been quite open, and it's theoretically still simple to offer promotions and to offer items of value as NFTs. And the reason is because as Colombian law has made a strong effort to define what they are not, certainly one of the things that was left on the air is that they are something. They have a value. They can be an intangible asset, and as an intangible asset, still a good under civil law regulation, and still can be valuable, and still can be sold, because also under Colombian law, anything that is not prohibited, it's allowed. I mean, that's a part of our constitution. So NFTs, or the commercialization of digital assets, is not prohibited in any way. The tricky part, the really, really tricky part, is in the very basics of advertising law. That is, how do you offer an item that nobody really know what is it about in a manner that is clear, that is truthful, that is adequate, and that is verifiable and understandable? Obviously, accurate and appropriate. So exactly, if you're going to offer a price, or if you're going to offer merchandising of items, or if you're going to sell any NFTs as good, how do you really know that your customers also know what you're talking about? Because this technological development that obviously took us by a storm, it's um, still unsettled on exactly what am I getting and what is the value of am I getting, for example, in terms of seeking authorization to run a contest or a prize, to offer a prize as an incitement for consumption. How do you value that? You don't know. It's very difficult to do it. So that's I will say that is the backdrop that makes it very difficult still for use NFTs as matter for promotions. Please, next slide. Now, nonetheless, as you see, the Colombian government has been trying to get into the game. So they decided that they were going to go to GoChain to do the minting of NFTs and facilitate the execution of agreements. And that was for the Expo Dubai, in which Colombia was going to be present, and they wanted to present something that we were also into this technologically advanced, I would call it manifestations, but still, it didn't have any value, it didn't have any relevance, it didn't create any waves. It was just to say, okay, we're trying to learn how to figure this out. Next slide, please. I will go into the two cases that we have had some activity. It was in the Copa America of 2021, in which CONMEBOL and obviously the Colombian Football Federation enter into a special offering of NFTs that was limited in edition and were added towards a special promotion of tickets towards the matches. So besides if you managed to sign the proper score of the different games, you got a special NFTs, which again the value was set at randomly. It was $234, and they put that value as such, not because there was any objective way to assess it, but because they needed to put a value that somehow will take it out of the minimum value necessary to seek authorization from the government to run the contest. Please, next one. And also we have the case of the largest football team in Colombia, which is Millonarios. So they decided to use the fan token as an NFT, which will allow them as a code to enter special promotions, special, how do you call it? Special, for t-shirts and mugs and all those, I forgot the word, and all those special rewards that somehow a fan can take up for a special in case of matches or awards, or to show their loyalty and to obviously create an item of identification. But this was mostly fashionable. I mean, this hardly have any relevant value, or that we see that it's being traded in a matter that makes it relevant. It's mostly like exploratory sort of advertising to join the fad. Next slide, please. So that will be it. I mean, there's not much to say on this topic. I would say it's very much on diapers and waiting to see how far can we go. And now next to China. Thank you.
Thank you so much. And now for our final presenter, we have Justina.
Hey, Hannah, thank you. My name is Justina. I'm a tech and advertising lawyer based in Beijing. Next slide. The mining, minting, and trading of Bitcoin and cryptocurrencies is banned in China. In contrast, non-fungible tokens are heating up in China under the name of digital collectibles. Despite growing restriction and tough regulatory environment, preventing users from selling their digital assets for cash. To understand this unique phenomenon, let's download our legal environment in China for virtual currencies and digital assets. Next slide, please. China's regulatory regime for virtual assets is still evolving. On the one hand, virtual assets are protected as civil property rights under the Civil Code, which serves legal basis for Chinese residents to own digital assets, including digital coins and tokens. However, it relies on other laws and regulations as to the legitimacy and protection of such virtual assets. On the other hand, virtual coin, cryptocurrency's initial offering, trading, and speculations are strictly prohibited. On September 15, 2021, the People's Bank of China, together with 9 other governmental departments, jointly issued a notice on further preventing and handling the risk of speculation in virtual currency transactions. It clearly states that virtual currency cannot be used or circulated in market as currencies. All virtual currency transactions are illegal. Also, for the first time, it states that overseas cryptocurrency exchange providing service to Chinese residents through the internet is also illegal. Also, their employees in China, as well as other companies, organizations, individuals provide service to the company, will be held liable in according to relevant laws, as long as they never should know the exchange are carrying out cryptocurrency transactions. Those documents also warn the legal risks of investing in cryptocurrency. Next slide, please. Non-fungible tokens' legal status is unclear. Whether NFTs will be treated the same way as cryptocurrencies or not are still pending or unclear. Some latest legal updates this year. According to a list published by the CAC, the regulator on the internet, on March 3, 2020, an NFT issuance or incubation platform has become one of the latest market players to complete filings to be blockchain-based information service provider. This clarifies the applicability of China's developing blockchain regulatory regime to NFT business. On April 13, 2020, industry associations, including the National Internet Finance Association of China, Security Association of China, and China Banking Association, jointly issued a proposal on preventing NFT-related financial risk, which sets some basic principles for NFT business. As an initiative intended to prevent NFT-related financial risk, it includes a commitment by members of these 3 associations not to financialize or securitize NFTs, including not to provide trading service or related financial service for NFT in any form. While these industry associations are definitely not government regulators, and the proposal have no legal effects, it may shed some light on future legislative direction. Next slide. This explains why the NFTs offered by tech companies in China adopt totally different rules from the remaining world. First, NFTs offered by this company use a neutral term as digital collectibles instead of token. Secondly, the forms of NFT are quite limited, mostly artworks. Third, it's not offered on the public blockchain, rather private consortium blockchain of these tech giants. Lastly, and most importantly, it's not tradable and cannot be resold for money. Next slide. Thank you. Although NFT's legal status is still unclear in China, the Chinese government may have zero tolerance for the financial use of NFTs. To use it as an IP protection tool seems being promoted and supported by local governments. For example, in Shanghai's 14th five-year plan for digital economic development, which was issued in this June, mentioned that support leading companies to explore building NFT trading platform, research and promote digitalization of assets like NFTs, global circulation of digital intellectual property works, and digital authentication of ownership to be piloted in Shanghai. Also, the first case on NFT released by Hangzhou Internet Court in this April, with implication for copyright and platform liabilities for NFT. One NFT platform sued another for copyright infringement, as one or more NFTs based on the work Patch Tiger series created and issued by the users of the defendant without copyright license from the plaintiff. The court held that the defendant had failed to fulfill its duty of care and take necessary measures to prevent infringement when it knew or should have known that its user had infringed another party's right. It ordered the defendant to cease the infringement and pay statutory compensation of RMB 4,000, around $600, to the plaintiff. Next slide. Although NFTs in China is not suitable, it can still be used as a marketing tool. Some are quite successful. This is Jingdong's offer of free NFT badges. Jingdong is an e-commerce giant in China, similar to Amazon. Next slide. The other case is McDonald's distribution of 100 digital assets in China last year, which seems quite successful as well. Next slide. Needless to say, this evolving regulatory situation put the market players in China in a very difficult position, including whether to continue to invest in NFT services or stop operating in the NFT sector at all. Recently, Chinese internet giant Tencent Holdings' non-fungible token platform announced that it would no longer release digital collectibles to the public anymore. Owners of existing collectibles will still be able to hold, display, or request a refund for their position. On the other hand, other platforms are still trying to continue to provide innovations that meet some of the demand for liquidity. For example, the Jingtan app operated by Alibaba now allows users to kind of exchange items in their collection, 15 digital collectible after 180 days of ownership. Next slide. The legal environment of NFTs in China is still evolving, which could be subject to certain changes. For marketing with non-fungible tokens, some takeaways. First, do not induce the public to believe that the virtual currency of NFTs can be used for payment or circulation. The safe description of NFT is to digital collection or digital collectible rather than a currency or token. NFT trading and speculation are not allowed. No marketing of NFTs high collection value, which may create a misperception that NFTs can be traded and speculated on. Rather, NFTs can be distributed for free by lottery or at a nominal price, indicating that NFT is for brand marketing, not to create significant direct revenue. Lastly, NFT platforms nowadays shall complete record filing with the regulator CAC. Other risks to consider including IP infringement risk and resolution penalty, money laundering, and data considerations. That's all I'm going to share today. Thank you.
Thank you so much, Justina, and to all of our presenters. And just some party thoughts for everyone. One thing we want to let everyone know is that NFTs may soon be regulated and controlled differently than they are now. So one really important takeaway is that we all need to remain nimble and prepared to reevaluate risks as the legal landscape unfolds. So we'll continue to update you as developments happen. And thank you so much for joining us today. We appreciate your time.